Hey everybody, this is Tracy here with another edition of A View from Tracy's Point, and we are here to finish up the opening statements. And we have June Brown's attorney who is about to go next. We've already heard from the government, Jennifer Bonjean, and LaDamien Bryson. And for those of you who are unfamiliar with this case, this is the United States in the Northern District of Illinois versus Robert Kelly, Milton Brown, and Daryl McDavid. And so this is the first day of the actual hearing. And then once we finish this up, it will go into the first witnesses that were called by the government. So let's go ahead and get started after this quick break. Okay, so we are going to pick up with the opening statements from the attorney for Milton June Brown. The government has already gone, Jennifer Bonjean, and LaDamien Bryson, who is the attorney for Daryl McDavid. And once again, this is the trial of the United States in the Northern District of Illinois versus Robert Kelly, Daryl McDavid, and Milton Brown. And so court kind of went by fast on this day. It picks up a little bit once we get into the witnesses coming on. And so after Milton Brown's attorney gives her opening statements, which are pretty brief, then we will get into witness testimony and the government witnesses. I believe there were 3 on this day. And so let's go ahead and get started. Court is returning after their lunch break. And I don't believe the jury isn't in at this point. They're clearing up some loose matters. And so Jennifer Bonjean stated, "I would like to put something on the record. I don't think we have all counsel." And then the judge said, "Okay." And then Bonjean, and then the judge said, "Okay, Miss Bonjean, you wanted to put something on the record." And then Bonjean says, "Yes, Your Honor, thank you. Your Honor, Defendant Kelly would move for a mistrial. Prior to trial, we moved to sever our case from Defendant McDavid. As the court may recall, the response was that we were manufacturing some type of conflict. I know the court denied that motion, and I'm just, for the record, pointing out that during the opening statements, it does seem to appear that Mr. McDavid not only intends to engage in some finger pointing, which this court has recognized may not be sufficient to justify severance, but fundamentally their defense is that ultimately these video clips were in fact CP, that just Mr. McDavid didn't know about it. So that puts Mr. Kelly in this position where he really can't defend against those claims. And also, I do have some concerns because it sounded to me as if Mr. McDavid was part of this legal team and that communications that were conveyed in the context of this legal team could be privileged communications. So I do think this creates some problem. I'm just moving for a mistrial based on those grounds and our prior motion for severance. Thank you." So Judge Lennon Weber, all right, thank you. The motion is denied. I don't think that that's a problem at this point. Are we ready? Want to have the jurors come in, please. So the jurors come in, and then the judge says, all right, you may be seated. And then the attorney for Milton Brown, her name is Ms. Leon, and it says, you may give the argument for Mr. Brown. And then Ms. Leon states, thank you, Your Honor. And then the judge, opening, not argument, opening statement on behalf of defendant Milton Brown. So, Miss Leon, hindsight is 2020. The government's case against Milton Brown depends entirely on the benefit of hindsight. The government is asking you to view this trial against Milton Brown based on all the information that is now known in 2022. When you have the benefit of knowing more information than he had available to him in the early 2000s, the government's case relies on the fact that humans have a hindsight bias, which is that human tendency of perceiving past events as having been more predictable than they truly were at the time they happened. They want you to believe that Milton Brown was part of this alleged conspiracy, but the evidence or lack thereof would prove that he was just an assistant who, day in and day out, fulfilled his employment duties. He had no knowledge of the secrets that his employer, Robert Kelly, held close and hidden from the world. He had no knowledge of any conspiracy and no knowledge that the individual portrayed in the VHS tape was underage. To understand why or how that is, we have to go back, way back. Y'all remember that song? What was it? Aqua Boogie or something? Okay. Forget everything we now know about Robert Kelly. We have to put ourselves in the shoes of Milton Brown from the late 90s to the mid 2000s. In 1997, small town Mississippi. Okay, why is she quoting lyrics from old rap songs? And wasn't this one of Stevie Wonder's songs? Mississippi, living for the city. Ain't that from Living from the City? I don't know. Anyway, probably not. Okay, native Milton Brown, unequipped with a high school diploma, moved to Chicago to be closer to his parents and with dreams of breaking into the music industry. Dang, everybody wanted to get into the music industry. He found that opportunity. He hit the jackpot when he was offered a position to work with R. Kelly. R. Kelly at the time was known as a multi-Grammy award-winning superstar with multiple platinum records, chart-topping songs, and a legion of devoted fans. This was the lens through which Milton Brown viewed R. Kelly when he began working for him in 1997. Now, she already out of pocket referring to this man as R. Kelly because it is Robert Sylvester Kelly that is on trial, and she should be saying Mr. Kelly. So Milton served as one of countless assistants to Mr. Kelly, and serving as an assistant to the celebrity meant wearing many hats. Milton served as a driver, taking Kelly and his family, Kelly's friends, singers, musicians, mentees, and their family wherever they needed to go. Milton served as a runner, a staffer who went to the bank and picked up cash at the superstar's frequent requests. Milton would even transform into a basketball player when the superstar needed individuals to play against in his late-night pickup games. You'll learn that these various tasks were not only asked of Milton, but also of the many staffers who worked for Mr. Kelly, lady. So the government wants you to believe that Milton served as a right-hand man to his employer, but you'll hear that Mr. Kelly surrounded himself with a number of people. The number of people at Mr. Kelly's beck and call, look, she keeps saying R. Kelly, but I'm changing it to Mr. Kelly. Beck and call on any given day and at any given hour range from agents to business managers, lawyers, accountants, a variety of artists, and other staff members. Some were high on the totem pole, others were assistants, runners, and errand boys, just like Milton Brown. During this trial, you will come to learn that one thing remained true. Every employee knew their place and quickly learned the rules in a carefully siloed system that Mr. Kelly arranged to keep staffers unaware of his private dealings. You see, from the beginning of Milton's employment, he had to follow well-established rules. Mr. Kelly implemented a system of control and isolation well before the thought-out well before and throughout Milton's employment, a system that kept everyone who was not on a need-to-know basis in the dark. You'll hear that guests and employees could not walk around Mr. Kelly's home or studios freely, if at all. Guests were confined to one space. Employees had to knock on any given surface and announce themselves before walking into or through any space within the home or his multiple studios. You'll learn that employees were not allowed to speak to and sometimes even look at guests. Males, including male friends of Mr. Kelly's and male staff members, just like Milton, were not to speak to any of Mr. Kelly's musicians, guests, or female companions. You'll hear from other employees that doing so meant risking their paychecks for days, weeks, months, or ultimately losing their jobs. Okay, now, I thought this was the defense attorney for Milton Brown. Why is she sounding like one of them Eastern District of New York attorneys? Like that? Wait a minute. Okay. Maybe these attorneys should have got together and worked together and be like, hey, we're not going to throw each other under the bus. We're not going to be repeating rumors and that type of thing. But anyway, Milton is her client, and this is what he's telling her. So we're going to go with it. So what did all of this mean for Milton? Well, Milton followed the rules. He kept his head down and did all the odd jobs he was asked to do as an assistant. This is the lens through which the evidence in this trial against Milton should be heard. This is the lens through which the evidence in this trial should be viewed. In 2001, many believed rumors circulating that Kelly had fallen prey to extortion and retaliation. Like many in the world, Milton believed Kelly was being blackmailed with a fake doctored sex tape. All right, let's get on board here. And that the individuals making these threats were motivated by greed and personal vendettas. This was a common explanation for the rumors around Kelly, one that was adopted by his fans and his employees alike. And those individuals making those threats, they followed through. They released the VHS tape. You'll hear testimony from one of those individuals, Lisa Van Allen. Okay, here we go. Who at that time was, in fact, attempting and charged with soliciting a bribe. Copies of that tape ended up on the street corners, in people's homes, and ultimately on the internet. Why? Because many people looking through the same lens as Milton and going off limited knowledge of Kelly's life believed the video to be fake. Testimony would show that at that time, as information regarding the tape circulated on the news, Rishona, who authorities believe was the female on the VHS tape, denied that it was her. At that time, her mother denied that it was her daughter on that tape. At that time, back in the early 2000s, her father denied that it was her on that tape. Deprived of the benefit of hindsight, knowing nothing more at the time, it was easy for anyone to believe the rumors of a fake sex tape were true. This would have been the extent to Milton's knowledge. This was the lens through which Milton and members of the general public were looking when they considered these buzzing rumors of a fake sex tape. And in 2008, when a Cook County jury acquitted Kelly of any wrongdoing connected to these tapes, everyone around Kelly, beliefs affirmed, went on abiding by his unwritten rules meant to control and isolate everyone around him. Milton was no exception. He continued his duties as an assistant, driving as a chauffeur to Kelly and the various artists under his employer's mentorship, carrying Kelly's bags to and from the car and bus, and picking up and dropping off money at Kelly's request. Milton would not have known more than the general public about what was being reported at that time. And the reporting at that time certainly suggested that this tape was fake. There will be no direct evidence that Milton knew what was on the VHS tape at issue in this case. Instead, the government will present circumstantial evidence that Milton might have been aware of some alleged conspiracy. They'll present financial records. For instance, they'll offer testimony about a check written to Milton 15 years ago that the government will argue was used to pay off co-conspirators. But you will learn that Milton routinely carried large amounts of cash for Mr. Kelly, the celebrity, whether he was on tour in America or around the world or right here in Chicago before, during, and after the events in question. You will hear that Milton did nothing outside of the course of normal employment duties as an assistant to Mr. Kelly. Never did he believe that going about his normal everyday work duties, or that by virtue of taking a job serving as an assistant to Mr. Kelly, his life would take this dramatic turn. But hindsight is 2020. If anyone asks who Mr. Kelly is today, you would certainly hear a much different perspective than what you would have heard if someone asked who Mr. Kelly was at the time in question. Sitting here today, you have the benefit of hindsight. But back then, when this alleged conspiracy is said to have taken place, Milton did not have the benefit. We are asking that you do not impugn that was gained. We are asking you do not impugn what was gained through decades of investigation across countless government agencies onto what Milton knew to be true back then. We are asking you to look through the same lens available to the world and Milton Brown back then, because, as you'll learn, what Milton did and did not know is crucial when weighing his guilt or innocence. Like all of Robert's employees at that time, Milton Brown had very little knowledge of his employer's private life, let alone his most closely guarded secrets. He had no knowledge and no reason to think that the tape was genuine. He had no knowledge of the identity of the person on the tape. He had no knowledge of his or who his employer really was. Okay, doesn't sound like she throwing Mr. Kelly under the bus and backing up over him? So after you have viewed all of the evidence and listened to all of the testimony through the lens of Milton Brown back then, we are confident that you will find Milton Brown not guilty of these charges. Thank you. Yeah, girl, go sit down somewhere. So Judge Lennon Weber, government calls its first witness, please, and then Jennifer Bongine. Judge, could we have a sidebar real quick? Then the judge says, all right, child. And I don't know what she said in that sidebar because it is redacted, but I think she called for another mistrial because she is sick of these people throwing her client under the bus. So it's the end of the sidebar, and the judge says the government calls its first witness. And then Ms. Puzzola, the government calls Dr. Daryl Turner. And Dr. Daryl Turner is sworn in. And then the judge says, please be seated. Remove your mask while you testify, sir. So Daryl Turner, government's witness, sworn direct examination by Ms. Pozzolo. Okay, so when we get into this questioning, it is question, answer. I'm not going to say Ms. Pozzolo and then Daryl Turner. I'll say it like the first couple of times to let you guys get in the flow of who's talking. But then after that, assume if somebody asks a question, it is Ms. Pozzolo. And when somebody makes a statement or answers, that it is Mr. Turner. And then if it gets a little confusing as I'm reading it, then I'll jump in and say, okay, it's Ms. Pozzolo, it's Mr. Turner talking. So we're going to start with Ms. Pozzolo. Good afternoon, Mr. Turner. Good afternoon. Ms. Pozzolo, can you please state and spell your name for the record? Yes, ma'am. I'm Dr. Daryl Turner, Darrel. And Turner is like it sounds. What is your occupation? I'm a clinical psychologist. Do you have a specialty in your practice? My specialty is in forensic psychology with a focus in the area of sexual offending. At a very high level, can you please tell us the difference between clinical psychology and forensic psychology? Sure. If I If I'm working in a clinical capacity, then I'm providing treatment, making diagnosis, treatment plans, recommendations, working at hospitals. And in forensic work, it's basically anytime there's an intersection between the law and psychology. I'd like to start out by asking about your educational background. Can you please give us an overview of your education? Sure. I have a bachelor's and master's in psychology and counseling psychology, respectively. I have a doctorate or a PhD in clinical psychology from Sam Houston State University, and I completed my pre-doctoral internship at a federal correctional institute for the Federal Bureau of Prisons in Fort Worth, Texas. Are you a licensed clinical psychologist? Yes, ma'am. What does it mean to be licensed? It means different things in different jurisdictions, but for the most part, you have to have, in my case, it was 2,000 hours of supervised practice after you complete everything and you have your doctorate. And then you have to pass it's called the EPPP, which is our version of the MCAT or something, jurisprudence exams. I had to pass an oral exam in front of the board and then submit for licensure with recommendation letters. And then every year you have to maintain your continuing education units and things like that. In what state are you licensed? Louisiana and Texas. And you stated that you do both clinical psychology and forensic psychology. Focusing on the clinical side first, can you describe the different areas that you practice? Yes, ma'am. I'm contracted with an inpatient psychiatric hospital locally, so I do rounds and help them with testing there. I do a lot of work with veterans who are getting out of the service or have been out of the service trying to get benefits and things like that. I also do testing for adults, but mostly for children, for special education programs and accommodations, things of that nature. And then I'm always involved in research and just basic evaluations that people request for various reasons. People that have substance abuse problems but are trying to get back to work or have access to their children again, things like that. Can you please describe what type of forensic work you do as a psychologist? Sure. A lot of the work that I do is competency evaluations, sanity evaluations for public defenders out of Houston, but most of my forensic work is in the area of sexual offending, the risk assessment and evaluation treatment of sexual offenders. In addition to the work you've just described, do you also work as a consultant? Yes, ma'am. In what capacity have you served as a consultant in the area of sex offending in particular? Well, sometimes I'll be asked to consult on an active serial case or a pedophilic offenders or serial rapist case, but remind me of the initial question. I think I got off topic. Oh, do you work with certain agencies, federal agencies, as a consultant as well? Oh, okay. Yes, ma'am. I work with the FBI, with NCIS, Homeland Security. I've worked directly with the military, and so those are some of the different agencies that I work with and consult with. But a lot of the time when I'm consulting, I'm working with victims of sexual abuse. I'm consulting on cases where there is numerous child victims, and I will go in and talk with them. I'm asked to do that a lot and with increasing frequency. During your career as a clinical psychologist, have you authored any publications? Yes, ma'am. What are some of the topics of those publications? A lot of what I was just talking about, things like grooming, and the impact that grooming has on victims of abuse. I've also published on and some of the instruments that we use in the field that would probably put everyone to sleep, and risk assessments in general, ethical considerations in forensic evaluations, and there is an instrument that I've invented that's being published now. In terms of research, can you please describe some of the notable research that you've conducted in the field of psychology? Yes, ma'am. We've done a lot of work in Texas with offenders and reoffense rates and looking at things, risk factors and protective factors that can raise or lower people's risk. I've worked with a tool called the PCLR, which measures the degree to which someone has psychopathic traits. And I've been pretty prolific in that area as it relates to offending. And again, I think I might have said this, but I've published on grooming and the impact, and that was on the victims long term as well as short term. Do you also present at international and national conferences? Yes, ma'am. As an example, can you tell us about a conference that you presented at earlier this month? Now, before I continue with this mess, child, this guy, they submitted in the motion to be able to include him, as a expert witness. They also included his resume, and when I tell y'all it was 198 pages, so I really hope she ain't about to go through all 198 pages of this. So his response to her question about a conference was, yes, ma'am. Wait, hold on. Yes, ma'am. I presented at the Dallas Crimes Against Children Conference, which is the largest conference of its kind in the world. There was about 6,000 people there, and I presented on grooming and the impact on victims. I was also asked to expert in a previous conference there about grooming and victim impact. I presented on paraphilic disorders and fetishes, and I did an introduction on the instrument that I told you about a moment ago. So, does your forensic specialty, as you've described it, include a focus on grooming practices employed by adult offenders who offend against minors? Yes, ma'am. That's been my primary area of focus, of testimony, and of research. And does your specialty also focus on the dynamics between victims and offenders, including the victim's disclosure of abuse? Yes, ma'am. All of that falls under the umbrella of impact that it has on the victim in many different ways. Do you also testify in court proceedings as an expert in the field of psychology? Yes, ma'am. Approximately how many times have you testified in state and federal court? I would estimate about 100 at this point, 100 times, give or take. In your experience testifying in federal and state courts, does that include testifying in criminal cases? Yes, ma'am. In the state and federal criminal cases that you have testified in, have you testified on behalf of the government? Yes, ma'am. And have you testified on behalf of the defense? Yes, ma'am. Out of all the testimony that you have offered in federal and state courts, can you estimate how many of these cases were in federal court? I believe, including this testimony, I'm at 25 appearances in federal court to testify. And of those court appearances, how many times have you testified about topics related to child abuse, including the grooming process and delayed disclosure by victims? Every time I've testified in federal court, that's been included, whether I've been called like this as a blind witness or whether, whether I've been, oh, come on here. Hold on a second. Whether I've been called like this as a blind witness or whether I've done an evaluation, because it was all been those types of cases. Court victims, CSAM cases. So it's, I've never testified in federal court about competency, for example. It has all been about sexual offending. Regarding your testimony in federal courts, does that testimony take place throughout the United States? Yes, ma'am. So then Ms. Pozzolo, Your Honor, at this time, the government requests that Dr. Turner be permitted to testify pursuant to Rule 702 on the topics of grooming practices and victim abuser dynamics, including the victim's delayed disclosure of abuse. So basically what they are going to do here is try and set the stage to justify why, when people, are victims, at one point it takes them a long time to come forward and tell their story. So they're setting the stage to say that even though Rashona called herself in love, which she would later testify to, and that she wanted to be with Mr. Kelly, and now that she's coming out, 20 something years later, that it really is about this psychology, the psychosis and the delayed reaction, and that is perfectly normal and should be taken into consideration. So the judge says, any objections? Bonjean, Judge, may I voir dire at this time? The judge, no, you can wait until he is crossed. Bonjean, okay, I do have an objection, but I'll wait. The judge, okay, objection is overruled. Go ahead. I find him to be an expert. Now you go deny the objection when she ain't even gave you what the objection is, child. So, by Miss Pozzalo. Okay. Question. Now, Dr. Turner, I'd like to ask you some questions about your testimony in this case. Have you reviewed any evidence in this case? No, ma'am. Prior to testifying, were you informed of the names of the defendants in this case? Yes, ma'am. Okay, I don't know why this thing won't go to the next page. And were you informed of the general charges in this case? Yes, ma'am. Aside from that information, have you interviewed or evaluated any of the defendants in this case? No, ma'am. Have you interviewed or evaluated any of the witnesses in this case? No, ma'am. Have you reviewed reports or other evidence documenting any of the facts of this particular case? No, ma'am. So, if you are not here to testify about the specific events that occurred in this case, can you please describe the nature of your testimony today? Yes, ma'am. I'm here to testify. Can I ask, is this the jury here? Yes, in the middle of the room. I'm a little lost. All right. I'm here to testify about grooming and what that involves and the impact that that has on victims, because the impact and the behavior of victims that are victims of childhood abuse is not what we would expect it to be. And so there's a lot of psychological manipulation that goes on. And I'm here to talk to you about just those facts in general. Okay. Okay, guys, I'm stuck on this page. For some reason, it will not page down. Okay, so is your testimony here today based on your education, research, and training and experience? Yes, ma'am. And this includes... And this includes information that you learned through your various studies and work done by other psychologists, correct? Yes, ma'am. As an expert witness, are you being compensated by the United States government for your time in this case today? Yes, ma'am. Now, Dr. Turner, the term grooming has come up a few times during the preliminary questions that I've asked you. Can you please explain to the jury what the general definition of grooming is? Sure. Grooming is behavior that an adult who desires to have contact with a child engages in to gain access to that person, to maintain access to that person, and to prevent that person from disclosing if possible. When you refer to a child, are you referring to individuals who are under the age of 18? Yes, ma'am. And from birth to the age of 18 is a fairly wide range of ages, correct? Oh, God. Yes, ma'am. Oh, I'm sorry. I don't know what is wrong. Why this thing keeps going back. to the previous page. In your field, do you have terms that differentiate between young children and older children? Yes, ma'am. And what are those terms? We look at children as victims as either pubescent victims or post-pubescent victims. And generally speaking, that is the age range for what is the age range for pre-pubescent child victims? It's for a pre-pubescent, yes. So it would be anything from birth until around 12 or 13, something like that. And why is the age typically 12 or 13 when the child is referred to as being post-pubescent? Because when a child is either almost through their puberty or finished with puberty, there are different hormones and things rushing around their body, and they actually start to think about sex, and they find themselves attracted to people. And we don't see that with prepubescent children. They're not at that level yet. So the dynamics of grooming and the impact of the abuse, there are a lot of similarities, but there are also, it looks differently when we're talking about pubescent versus prepubescent children. Now, you stated that when it comes to grooming, there are some similarities for all children. Can you describe, based on the research and... Okay, hold on a second. Tell you, my computer is going crazy. Can you describe, based on the research and the psychological community, some of those methods of grooming that are commonly used regardless of age? Yes, ma'am. Across research and in my own research, we found that when you talk with offenders, the number one goal is to establish some kind of trusting and close relationship. Now, for younger people, that may be more of a parental role or a friend or something like that. But for post-pubescent, younger teenage children, very often we see it in the context of what is proposed to them as a romantic relationship, but that establishing of that relationship and the ways that is done are the things that are common across ages of victims. And what are some of the other techniques that apply to victims of all ages, aside from that creation of the special relationship that you just discussed? Well, there is a few things that we always see in grooming. We always see isolation of the victim by the intended offender. And then we see over time a gradual kind of introduction and normalization of sex with the victim and between the victim and the offender. In other words, letting the victim think that it's okay and that is something that everyone does and they won't get in trouble. And it's a good thing. So just normalizing it over time verbally and with touching, I should add. Question. Okay. Can you elaborate more on how touching factors into the grooming process? Yes, ma'am. When someone is grooming an intended victim, it's very rarely as an ambush. Kind of all of a sudden, everything that's going to happen is going to happen right up front. What we see is a graduated introduction of themes and ideas. So maybe hugs, and then maybe the hugs become squeezes. And then we see, pats on the bottom, and then that becomes squeezes. So you see a progression. And what that does is it slowly indoctrinates the victim into feeling comfortable in that contact. And it also serves as a kind of testing with waters for the offender, because if the offender gets to a point of touching with the individual, then where the individual becomes uncomfortable, then it's time to either back up or slow down or go to another victim. Question. Is one way to introduce sex based on the research conducted in this field showing the victim porn? Absolutely. And why is that one of the methods of grooming that has come up in the research in this field? Well, especially since the internet. If you look at old studies, that was used to an extent. If you look at current studies, it's used all the time. What that serves to do is, and it usually starts as kind of like, hey, come look at this funny video, or I accidentally left my porn up on my laptop and that worked and they walked in. Something of that nature. But it's just that, adults and children don't look at porn together. So it's presented as this sort of, hey, this is just something harmless and fun, and look at what they're doing. And what that does is it places that sexuality in the middle of these two people. It's also served in some cases as like a training, because the children are also young, that the offenders will show them porn to kind of show them what they want them to do or train them, that sort of thing. Now, you've just described some grooming methods that in your experience are used to groom all children. Looking at post-pubescent individuals in particular, are there other methods or things introduced to the relationship that are found more commonly with post-pubescent children? Yes, ma'am. And what are some of those? Okay, with those individuals, so 13, 14, 15, 16, we see the offender tend to do things like give alcohol, give drugs, let them get away with things that they're not supposed to do, like being out and staying out, special attention, special focus, less restrictions. And then with those individuals, we very often see that the relationship is presented to them as, I love you, and this is special, and I know that you love me. Oh, gosh. And I know that you love me too, and the world says this is wrong, but we feel that it's not wrong, and look how magical this is. So it takes often a romantic turn once the person has reached that age. Banjin, Judge, I'm going to object to the doctor's general testimony that it often does this. This is very anecdotal. It doesn't sound based on research or so this is just anecdotal and has no application since he has not examined Mr. Kelly. So I'm going to object to this line of questioning, particularly to the extent that he is talking about, we often see this, we often see that. Lennon Weber, overruled. You can tackle that on cross-examination. Banjin, thank you. Ms. Pizzolo, Dr. Turner, you mentioned isolation as one of the areas that comes up in grooming research in your experience. Can you describe for the jury more about what you mean by isolation? Sure. The offender is going to try to isolate the victim as much as they can physically. And when it can't happen physically, then there's a lot of contact. There's emails, there's phones, there's social media, there's texting. So what isolation does is it prevents other people from going, hey, hold on, something's off here, something's wrong. This doesn't seem right. Is everything okay? The more time the offender can spend with the individual, two things happen. There is less chance of someone else coming in and fixing things. And number two, this gradual indoctrination of ideas and sexuality can continue uninterrupted. So when you refer to the concept of isolation, does that always require physical isolation? As much as is possible, yes. But we do see that happening online now that social media is so big as well. Now, given that your research and experience is in adult offenders and child abuse victims, have you studied the area of the power differential, and can you explain what that means? Yes, ma'am. For children and adults is For children, an adult is, someone that you have to listen to, that you have to obey. It's someone that has a certain amount of power. And so that power differential is something that makes the grooming process go much smoother, because the child is already in a position where they feel like they're a little subservient to the adult anyway. So especially if you have someone that's like a teacher or a coach or a politician or something like that, then you have an even greater power differential. So that's a huge part of the grooming process. And as much time is spent between the offender and the child, and the grooming process, as you've described it, is ongoing, how does favoritism factor into that process? Favoritism is huge. I've interviewed thousands of offenders. I've worked hundreds and hundreds of cases. I've interviewed and done therapy with hundreds of victims. They all, there is such. In the majority of these cases, they'll tell you that they felt so special in the offender's eyes. They received so much attention, so much favoritism. They were their favorite child or favorite student or whatever the case may be, and they were very, very special. And that's what children want to hear. They want to think. So that's how favoritism becomes such an effective grooming tool. Now, you also testified that abusers commonly introduce the idea of sex gradually, sometimes through conversations and sex first. Is that right? Yes, ma'am. Does the grooming process also include conversations and topics that are not sexual? Almost always, yes, ma'am. And how does that work in terms of the research and experience that you have in this area of grooming? Well, what happens is that as when an offender just spends platonic, healthy attention time with the victim, it does two. Hold on. It does two things. It lowers the defenses, and then when people are asking the victim about things, if they do, then the victim can point to all of this just regular conversation that they've had. In addition, when adults find that out and other people become suspicious, it acts as this sort of plausible deniability. Well, hey, it's not, he was talking with her. I spoke with the victim or him, and there was a lot of time that there wasn't any kind of sexuality going on. That happens especially early, so that makes caregivers feel more comfortable allowing this contact to continue, very often unsupervised. Dr. Turner, you mentioned that adults close to the victim may start finding out or asking questions. So my follow-up question on that is, how does the grooming process relate to the child victim's parents or close family members? This is an element of grooming Okay, after the contact has progressed to the point where it's whatever the adult intended in the first place, there is still an element of keeping the child available for contact. And that's done by this continued reinforcement of whatever the special relationship that's been created was. That's reinforced. And then also remember that grooming is in part the goal is to prevent disclosure. So the grooming process becomes things like, hey, don't tell, and it's not, or I'll get in trouble. It's very often, we'll get in trouble, you'll get in trouble, because the victim is groomed to believe that they are responsible for their own abuse. Question: in situations where the victims are post-pubescent, I'm so sick of this dang on cursor. Post-pubescent or over 12 or 13, has your research and experience shown whether victims develop romantic feelings toward their abuser? Yes, ma'am. And as the victim's love and attachment to the abuser grows, what does your research and experience show about how the victim views her role in the relationship? Well, this happens all the time. Research indicates that law enforcement believes in post-pubescent victims that over half of them truly feel that they're in love with their offender. Bonjean. I'm going to object to the use of statistics in the course of this examination. Judge, if you want to do a sidebar, okay, wait a minute. So Bonjean says, I'm going to object to the use of statistics in the course of this examination. Judge, if you want to do a sidebar, I can give a better argument, but I think statistics are inappropriate. There is authority for that. Weber, overruled. He is an expert. He can rely upon research that he considers valuable. Bonjean, that's fine, Judge. I'll handle it on cross-examination. The witness, can you repeat the question? And then Ms. Pozzolo, yes. As a victim's love and attachment to the abuser grows, what does your research and experience show about how the victim views her role in the relationship? The victims, especially post-pubescent victims, when the relationship that's created is one that's, couched in love and a very special connection, it becomes less and less likely that the victim will disclose. And it also, we see even well after the abuse has stopped, that a lot of these victims will still be defensive of their offender, will still feel in love with their offender, even into adulthood will reach out to their offender, and they also feel especially culpable and responsible for what happened to them because of how they were groomed. After the abuse begins and is ongoing, why? What does the research show about why a victim does not report it to an adult, such as a parent, teacher, or police officer? Primarily because of what I said earlier, because at that age the grooming is usually, the efforts to prevent disclosure is usually no one is going to believe you. You're going to get in trouble. Something catastrophic is going to happen to your family. We are going to get in trouble. And in about 20% of cases, my research has found, and is replicated by other studies, about a fifth of the time at the point the offender can say, if you disclose this to anyone, if you tell anyone, we won't be able to hang out anymore. We won't have this relationship anymore. And even though that relationship is based on abuse, it has become so important and sensual in those victims' lives that a lot of times they won't disclose, simply to not lose and contact with their own offender. Has there been research conducted on the timing of disclosure by child victims? Yes, ma'am. And can you please walk us through what some of those research studies show? There's 3 very well-known studies that have similar findings. About 60 to 80% of children that are abused don't report it at all until adulthood. About 20 to 25% never report it. And about 60% wait at least 5 years before they disclose anything. And that may not be a full disclosure to law enforcement. That just may be telling a friend a part of it. So that's what the research indicates across studies. Your Honor, may I have one moment, please? Pardon? May I have one moment to confer? All right. I have nothing further at this time. Ms. Bonjean, you may cross-examine. Thank you, Your Honor. So here come Ms. Bonjean. Good afternoon, Dr. Turner. Good afternoon, ma'am. First of all, to be clear, you've never met my client, Mr. Kelly, correct? Never. You've never met any of the witnesses in this case who are going to testify, right? Correct. You've never examined Mr. Kelly, correct? No, ma'am. not examine any of the complaining witnesses. Am I right about that? You're right. Have you watched the docuseries Surviving Lies? No, ma'am. And you have no idea whether the charges lodged against my client are in fact true or false or somewhere in between, right? I have no idea and no opinion on that matter. And you, in fact, don't even know whether my client has ever engaged in any grooming of anyone, do you? No, ma'am, no idea. And isn't it true that not all people who are alleged offenders even engage in grooming? We don't see grooming when they are ambushed, like grabbing people from a parking lot or something like that, attacks or opportunistic attacks, usually involving substance intoxication. But any long-term abuse, I've not seen or worked or read about a case that didn't involve grooming of some kind. Well, you provided a number of articles to the government that you rely on to, I guess, develop your opinions here, right? Yes, ma'am. One of them was called Okay, I lost my page. I think it was called Self-Regulation of Sexual Grooming. Is that familiar? Yes, ma'am. And even in the article, which I assume you're familiar with since you provided it, right? Yes, ma'am. The authors there, the scholars, say that many, but not all, offenders demonstrate behaviors that could be defined as grooming. Isn't that right? Yes, ma'am. I want to go back to your credentials a little bit. You said something about a doctorate and a PhD. Which one are you, a doctorate or PhD? They're interchangeable. It's the same thing. Well, do you have a PhD, like on your certificate, like that you graduated from, or do you have a PSY.D? It's not a PhD. Okay. And you said your area of interest was sex offending and risk management, right? Yes, ma'am. In fact, your dissertation was on civil commitment on violent sexual offenders, right? Correct. And to be clear, you just graduated with your doctorate about a little over 10 years ago? Yes, ma'am. And you became a licensed clinical psychologist in 2013. Is that right? Yes, ma'am. Do you hold any faculty positions? I did. I don't anymore. You're not a professor at any institution or higher learning presently. Is that right? Not presently, not anymore. Yes, ma'am. You had some teaching experience at the University of Phoenix, right? In Argosy, and also at the school that I graduated from, McNeese State University. Yes, ma'am. Okay, the University of Phoenix is an online school, right? Right. It doesn't have a graduate program, right? I know I've taught graduate classes. I can't remember if they were at Phoenix or not. That was several years ago. I haven't done that in a while. Where did you teach graduate classes? I taught graduate classes at the university where I got my bachelor's and master's degree from. And then I also taught graduate level classes, I believe, at Argosy, Argosy. And when was that? That would have been 2014, 2015, something like that. And to be clear, your opinions here today are based on your personal clinical experience and stuff you read, right? They're based on my research. They're based on the body of research in our field, and they're based on my training and my experience. Yes, ma'am. And let's talk about your training. After you earned a license, you worked as a staff psychologist in the Federal Bureau of Prisons, right? Yes, ma'am. You treated prisoners. You were I guess, a psychologist that treated prisoners in the Bureau of Prisons, right? Yes, ma'am. All types of prisoners, not just sex offenders, correct? Correct. And I guess you also treated victims there because R is obviously something that happens inside prisons, right? Yes, ma'am. You indicated that you treated victims of abuse, but you haven't treated child victims of abuse, right? No, ma'am, I have. And in what context have you treated victims of abuse? Locally, sometimes when I'm asked to consult on a case, it's only to work with the victim, and that happens often. I do work with adult victims of childhood abuse, but I have a lot of experience working with children just coming out of the abusive relationship, helping them normalize what happened to them and understand they're not the only person that has these feelings and these experiences. And then also, I've worked with civil cases involving schools or state homes for children that were systemically abused, and I worked with those victims and as well, so I have a lot of experience in that. When you say worked, do you mean you forensically examined them? Yes, ma'am. Sometimes forensic examination to look for things like PTSD and make treatment recommendations and things. If they're not in my area, but first of all, I wouldn't do an evaluation and recommend that someone sees me for treatment. That would be unethical. But I do see victims strictly for treatment that are children. Yes, ma'am. Okay, so that's part of your private practice, is that right? Yes, ma'am. And do you keep data about the information that you learn through your clinical treatment of victims? How do you mean, do I keep data? Well, you testified here in response to the government. We always see this, or we, in almost all cases. And I'm wondering if you actually keep data from your own clinical experience that allows you to make these types of sweeping statements. Yes. So you do keep data of like where you are keeping it in a file and then studying it. How do you do this? Yes. Okay. So you have that data? Yes. And have you used that data in connection with any studies? Yes. Okay. What studies? I've designed an instrument that looks at denial patterns because I treat offenders as well, for offenders that are in treatment. And then also, as I've worked with victims, so that one's impressed. It's it's being published. And then also, I have a study that we started about 6 months ago where we work with childhood victims and we look at things like sexually problematic behaviors and what they're acting out or not acting out looks like when the abuse has stopped before and after treatment. Okay, but the first thing you mentioned was working with sex offenders. I was talking specifically about child victims of abuse. I thought you were asking about my records from these type of cases. No, I was specifically asking about child victims. Oh, okay. Well, I answered that in the second half. Sorry about the digression. That's all right. You've actually never published anything about child sexual abuse, have you? No, I have. The grooming study that was published looks at the impact of grooming on the victims and delayed disclosure. Yes, ma'am. Are you talking about grooming and other offense-related behaviors? I think that's right. It has been a while since I've looked at it. Okay, and where is that published? That was a professional conference, so it went through a peer review process of researchers and psychologists, the same as it would for a journal, and so we consider that a publication. You consider it a publication? No, ma'am, our field would consider that a publication. Well, if somebody wanted to go to Google Scholar, you know what Google Scholar is, right? Yes, ma'am. What is it? Come on, Jennifer. Don't do this man like this. It's a search engine for research articles, and that article would not come up there with it. No, ma'am, it wasn't published in a journal. It wasn't published in any scholarly publication, right? Correct. It was published at a professional meeting. Well, you presented at a professional meeting, but it wasn't published in a scholarly journal, right? No, ma'am. I present all over the world at professional meetings, and I don't consider all of those publications, but that one went through a peer review process. It was a professional meeting, and those are considered publications by anyone in my field. I'm not just padding my CV. I don't need to do that. And that particular publication actually looked at offenders' self-reporting behaviors, right? Correct. You didn't speak to any victims in connection with that study, did you? No, ma'am. But the article talks about the impact on victims. Right. No, ma'am. But the article talks about the impact on victims. So that was Mr. Turner answering her. And then she replies, right. You're concluding that the impacts are on victims based on your conversation with offenders. Well, no, ma'am. I'm making those conclusions based on my work with victims. Okay, your article that you say is published does not involve any interviews with children or even adults who were victims of abuse, does it? No, ma'am. And in fact, on your CV, correct me if I'm wrong, I didn't see any publications on the area of that focus on sexual abuse victims. No, ma'am, I haven't published something with that name. Well, how about anything like that focused on actually looking at the child victim's point of view? I didn't see anything like that. No, ma'am, no publications, just experience, education, and training. And you would agree that, as a psychologist, when you draw general conclusions about a population of people, you need to base those conclusions from a sample that would be representative of that population, right? Yes, ma'am. And can we agree that people in prison does not necessarily reflect a general population? I don't know why we're talking about people in prison, but I would agree with that. Yes, ma'am. Well, a lot of your work was in prison work, correct? No, ma'am. I was supervised towards my licensure while I worked in the Federal Bureau of Prisons, and I did work with offenders there, but the majority of my work with victims has been in my private practice. Right, and you started your private practice in what year? 2012 under supervision and 2013 as a licensed psychologist. Okay, how much are you being compensated here today? Oh, $250 an hour. All right. And how much have you charged the government for your work on this case? I think 2 hours at this point. So, not counting today. Today would be more, but prior to today, 2 hours. Okay, so you've committed all of 2 hours of preparation for your testimony here today. Is that right? Right. Not having to interview anyone or review any evidence really cuts down on the amount of time that I have to build. Now, isn't it true that amongst scholars, the definition of grooming is not really a set definition? There's a lot of disagreement among scholars about what grooming is, right? I wouldn't agree with that statement. Well, let's see. In this article, one of these articles that you looked at, give me 1 second. Well, the first sentence, actually, of this, a self-regulated model of sexual grooming, says that numerous commentators, however, have documented difficulties in defining and understanding the process given its transient nature and its specificity to this one form of criminal behavior. Isn't that right? That's what the article says. Yes, ma'am. There is a reason for that, though. And it's not just that article. There's quite a few articles that discuss the difficulty in defining grooming, right? I don't know about a few, but everyone wants to be the person that gives grooming the definition that everyone uses. My definition is something that I think anyone can understand. There's people a lot smarter than me that publish stuff, and they can have at the definition. So they can argue about who's right and who's wrong. But in general, it's what I said. It's behaviors designed to have access to victims, keep access to victims, create a bond, and prevent disclosure. I think everyone would agree with that. Okay, well, you didn't even agree with that yourself when you testified back in, let's see, 2012. Has your understanding of grooming evolved since then? I'm sure it has. Yes, ma'am. That's a long time, and there's a lot of research coming out. Right. So that's back to my point. The scholars have some disagreement among themselves about about what qualifies as grooming, right? There may be some disagreement, yes, ma'am, on the specific wording of the definitions, but again, in general, I mean, grooming is something. It's the same as depression. People might differ as to what they think depression really is, but we all know that depression is as practitioners. We all know what depression is, okay, as practitioners. Well, when you testified back in 2012 in federal court, you were asked about what is meant by grooming, and you answered that grooming is a term used to describe behaviors that offenders engage in primarily to get victims not to tell. Okay, yes, ma'am. Today, your testimony is grooming is more than that, right? Sure, I've learned a lot in 11 years. I think I was an intern at that point. Yes, I am. You were testifying in federal court as an intern? Yes, ma'am. You were qualified as an expert when you were an intern? I don't remember. I had my supervisor there. He was practicing on somebody's case. And I think it was just one of those, just let's let the kid get on the stand and have have that experience sort of thing. There was a defendant there that was being charged with a crime, right? Then Ms. Pozzolo jump in. I object to talking about a defendant in another case. I don't know what the witness even knows. He may not know specifically what case we're talking about, the court. It's cross-examination. Let's move it along. So there Miss Bonjean, she jumps back in and says, yes, you testified in a criminal case as an intern, and just your view is just let the kid get on the stand and see how well it goes, how well it does. Well, I'm being light about it, but I was the one that had done the evaluation. So my supervisor who went over the evaluation was there. She testified and then I testified. It was a competency hearing. He wasn't competent. Okay, now you claim to be an expert in, well, before we go there, I want to ask a couple of questions. I'm sorry. You talk about my research, one of the factors of grooming you talked about was this, that I guess victims see that as a romantic relationship. Is that right? Post-pubescent victims mostly, yes, ma'am. Okay. And can you point me to the research that you're relying on for that? Yes, ma'am. There is research about sexually problematic behaviors, and that's by a researcher named, in Louisiana, we would say Hebert. I think it's Hebert here, maybe. But they talk about the sexually problematic behaviors that you see in prepubescent children, and then they talk about how it's more a relationship, more of a sexual romantic relationship when they're older. Okay, this isn't research you conducted, right? No, ma'am. You're not an experimental psychologist, are you? You don't have to be experimental psychologist to conduct research, ma'am. Well, we all could read the article, I guess, and apparently take the stand and testify about it. But I'm asking you whether this was research you conducted. I don't think anyone in this room could read that article and get on the stand and testify as an expert. I've spent the last 15 years of my life studying this. Okay, and you pointed us to a paper that was original research by another person, right? Correct. You said we always see isolation. What do you mean we always see? Who's we? Jennifer Bajin is so wrong. Professionals, people that work these cases, and always sounds like 100% of the time, or were you being casual? Well, as I testified earlier, we don't see it in these ambush, opportunistic abuse cases. But anytime there's interaction with the offender and the victim over time, I've never worked a case or read about a case where there wasn't some effort to isolate the victim in some capacity. Do you have any research that supports your view, your opinion, that there is always an element of isolation in abuse, in sexual abuse cases? Well, it's not always, as I just said, depending on the type of case it is, but okay, fair enough. Taking out the ambush, the jumping out of the bushes rape situation, taking that out, do you have any data to back up your claim that we always see isolation? Across studies in my research on grooming, I found that, and then there are other authors that I could name if you want me to, that talk about isolation as being probably the most frequent behavior that's seen in the grooming process. And again, this isn't original research you've done. Working with victims, this is stuff that you have read and studied, right? Right, but my research on grooming involving offenders, we learned about that as well. You identified other factors such as normalizing of sexual behavior, right? Yes, ma'am. Again, this is data that you have learned from reading other people's original research, right? And from interviewing thousands of sex offenders, interviewing and working and treating hundreds of victims in my education and training. Yes, ma'am. You say thousands of sex offenders? Easily. Yes, ma'am. You mentioned things such as showing the victim porn, right? Yes, ma'am. Again, this is a factor that you derive from research. That's a study by Woloch. And then there is more recent study by, I believe it's Dr. Finkelhor. Okay, Finkelhor, looking at pre-internet and post-internet grooming techniques and how the use of showing pornography, producing CP of the victims has increased exponentially since the internet explosion or whatever. Now, you also discussed on direct examination delayed disclosure, or something known as counterintuitive behaviors of assault. Is that a term you're familiar with? Yes, ma'am. Okay. And you talked about some of the data around delayed disclosure of victims of child abuse, right? Yes, ma'am. And are you differentiating between child sexual abuse from intrafamiliar family versus non-family? There are some differences that we see, but I was asked about in general, so I was responding in general. But you provided an article about that I assume you relied on called Variables and Delayed Disclosure of Childhood Abuse. Yes, ma'am. And did you rely on that article as a basis for your opinion about delayed disclosure? Yes, ma'am. But that article deals primarily with like incest and intrafamiliar child abuse, doesn't it? Yes, ma'am. Do you have any reason to believe that this case is a case about incest? I have no idea. You don't even have that basic understanding of this case. Is that right? Absolutely not. You also relied on a paper called Prevalence of Childhood Abuse and Timing of Disclosure in Representative Sample of Adults from Quebec. Yes. Was that the article that you were relying on when you were talking about your statistics about delayed disclosure? Yes. Was that the article that you were relying on when you were talking about your statistics about delayed disclosure? No, ma'am. Those are three articles from three of the leading researchers in that area, and their findings were the same. So I was citing three different studies. Were they the same? It looks like there's a collection of retrospective studies in that seem to be not all consistent with one another. You're always going to be able to find research that you know is higher or lower than other research, but the general findings among the more respected higher tier publications are the statistics that I gave to the jury earlier. In fact, there is a general consensus, isn't there, that there is disclosure at the time of abuse by a good third of child sexual abuse victims, right? Again, that's going to vary from study to study. But one thing you have to keep in mind is that that's not necessarily disclosure to law enforcement or to a parent. So it may be disclosure that doesn't go anywhere. And there are statistics about how many sex offenses end up in arrests and convictions. And it's very, very small. Yeah, I wasn't really asking you about that. I'm relying on the study that you provided, that you were relying on, that demonstrates that depending on which study you're looking at least a third, up to 87%, there is childhood disclosure of abuse. Okay, are you disagreeing? It sounds different than what you testified to on direct. So I guess I'm trying to get clarity. I think you know that study has some other good things in it. I think that those findings aren't commensurate with what most of the findings on the field and the research over the years have been. Well, this was a retrospective study it was a meta-analysis. What's a meta-analysis? It's a study of studies, right? So these were 11 different studies were looked at, right? Yes, ma'am. And this is what you provided. This is not even something I'm pulling out of Google Scholar and hitting you with. This is something you provided. And it actually does show a range of childhood disclosure from about a third to 87% in this retrospective study, right? Right. Right. Dr. Turner, one reason sometimes there's delayed disclosure is because there is false reporting, right? That only happens in about 4% of cases, and usually that's in a child custody or divorce proceeding. Where are you getting your data that it only happens in about 4% of cases? That's a study by McClendon, who's a psychologist out of Scotland, I believe. Are you familiar with Dr. Zutter? A recent study about the rates of false reporting being much higher than that? I'm not, no ma'am. You certainly are aware that there are recognized motivations for false reporting. Scholars agree on that, right? Yes, ma'am. Can you tell the ladies and gentlemen of the jury what some of those motivations are for false reporting? The most common ones, as I said, are custody situations or divorce proceedings where there's a lot at stake and custody of the children is at stake. That's when we see most false reporting. Well, give me 1 second. Are you familiar with the scholar Zutter and his paper, Motives for Filing a False Allegation? I'm not. No, ma'am. Okay. And false allegations, you mentioned a scenario of where there is some type of custody dispute. But motives for false reporting are generally accepted in the scholarly community in 8 different categories. Isn't that right? Again, I'm not familiar with him or his article. Okay, what about Canaan? Are you familiar with Canaan? I believe I've read an article by Canaan, Dr. Canaan, before. Yes, ma'am. And a list of motives by Canaan. The most cited list of motives include material gain, alibis, revenge, sympathy, attention, a disturbed mental state, relabeling, or regret. Are you familiar with Canaan's work on identifying those categories of false reporting or motives for false reporting? No, ma'am, I'm not. But that's very different from what I'm talking about. A lot of those that you just said could be lumped into these custody and divorce proceedings, renaming and regret, and things like that. So, I mean, it sounds good, sounds right. Okay, you talked about isolating as a feature. Have you ever had a case where an offender allegedly would isolate an entire family? I have, yes, ma'am. And in that particular case, were their parents involved? Yes. And were they complicit in the sexual abuse of a child? No, ma'am, not in the case I'm thinking of. No, ma'am. Have you seen that though? Yes. Banjin, give me 1 second, Your Honor. Court, are you almost finished? Banjin, I am almost finished. Okay, you are finished or you're almost? Okay, this old ass man needs to get somewhere and sit down. Banjin, almost finished. I have a couple more questions. I overlooked one area I want to look back to. And then she turns around going back to her questioning. You discussed sort of the difference between prepubescent and post-pubescent, right? Yes, ma'am. And you put an age on it, but that's not the age itself is not a hard line, correct? Correct. I was citing the Diagnostic and Statistical Manual 5 that we use for diagnosing and things like that. They give a general age like that. But of course, when you have more information about the development of the child, you would use the information, you would use that because it varies for children. Right, because it does depend in part on the development of the child, right? Yes, ma'am. When they actually go through puberty, right? Of course. And again, you have no independent information about the circumstances of any of the alleged victims in this case, correct? Correct. Banjin, I have nothing further, Your Honor. Judge, okay. We will take a 15-minute recess. We have to switch court reporters and the jury can go out. Whereupon there was a change in the court reporters. So child, they back and the judge, he's still tripping, okay? So he says, please be seated. Any questions on behalf of McDavid? Then Mr. Brindley. No questions, Your Honor. On behalf of Mr. Brown, yes, Judge. Okay, Miss Judge, you may question him. Thank you. Cross-examination on behalf of Defendant Brown. By Miss Judge. Okay, one of the reasons an offender engages in grooming, you said, is to keep an unlawful sexual relationship secret, right? Yes, ma'am. And the technique of isolation or isolating victims is also done by an offender to prevent others from understanding or knowing about an unlawful relationship, correct? Yes, ma'am. And if I could add, it's also to reinforce the grooming process across time. But yes, ma'am. I'm sorry. Can you repeat that answer? Yes, ma'am. It's also, the purpose of that is to not only, it destroys the victim's frame of reference. So it prevents other people from providing a frame of reference. And it reinforces what they're being told about sex and sexuality. Thank you. Yes, ma'am. In your experience, do offenders engaging in unlawful relationships also engage at the same time with lawful relationships or sex with adults? Yes, ma'am, it can happen. And in your opinion, does it happen as a method to deter others from thinking that you're having relationships with unlawful relationships? Banjin, objection. Foundation. Court, objection overruled. Banjin, I'm not sure I understood the question, but I did lodge a foundation objection to that question. Judge, okay, he can answer. So, by the witness, do you mind repeating it, please? And then Miss Judge, sure, I'll try and make it clearer. No, it was fine. I just forgot what it was. Okay, in your experience, do individual offenders who have sex with minors also have sex with adults? And you said yes, correct? Excuse me. Yes, ma'am. And then my follow-up question was, in your opinion, do offenders have sex with adults as part of the cover-up or part of the grooming? It depends. It can happen when you diagnose someone with pedophilia, which is a sexual arousal to prepubescent children, or hebephilia, which is a sexual arousal to 13, 14, 15. You put a specifier as exclusive or non-exclusive, and that means they're either only attracted to children or they're also attracted to adults. So sometimes what you're saying can happen, sort of like a beard, kind of to hide what's really going on. But sometimes they can have functional, healthy relationships with adults while still offending against children. And in your experience, is that unusual to have relationships, healthy relationships with both adults, and then also be someone who has sex with minors? I would not characterize that as unusual. No, ma'am. Okay, one last question. In your opinion, can it be difficult for others to recognize grooming while it's happening? Absolutely. Thank you. Yes, ma'am. Okay, why would Milton Brown's attorney, I think Milton Brown, them public defenders he working with, I think they working with the government, because Milton Brown is only charged with taking them folks over there to Mexico or wherever he took them. That's all he charged with. Why? Why would his attorney get up and ask these questions, sort of like a cross for the government, instead of anything that relates to her client? So, child, the judge said redirect, and then Miss Pizzola, none from the government, Your Honor, because our person just already did the redirect that we were going to do. Mr. Brown's attorney that did the redirect for the government. Oh, child, just shady, and messy. So then the court, okay, you can step down, sir. So the witness, thank you, Your Honor. Witness excused. Judge, call your next witness. So now Jason Julian, who's another prosecutor for the case. Your Honor, the government calls Ann Meckelborg. So Ann Meckelborg, plaintiff's witness, sworn. The judge, you may remove your mask while you testify. Thank you. And then the witness says, thank you. And then the judge says, Mr. Julian, you may question the witness. And then Mr. Julian, yes, Your Honor. So direct examination begins. Good afternoon, ma'am. Hi. Could you please state your name and spell it? Yes, it's Ann Meckelberg. A-N-N-M like Mary, E-C-K-E-L-B-O-R-G. Meckelberg. Okay. Let's see. Let's go down here. Miss Meckelberg, for who do you work? I work for the National Academy of Recording Arts and Sciences, Incorporated, which is also the Recording Academy. I'm just going to call it the Recording Academy, okay? That's fine. What does the Recording Academy do? We are a membership organization and we produce the Grammy Awards. What is your role at the Recording Academy? I'm the Senior Managing Director of Contract Administration and the Corporate Secretary for the organization. So, what are your duties as the Senior Manager Director of Contract Administration and Corporate Secretary? So, I oversee all the documents and all the files and paperwork that comes through the organization at a fairly high level. And all the different departments manage their own items, but then it all comes up through my office. Are you the custodian of certain records for the Recording Academy? Correct, yes. What types of records would you be the custodian of records for? Well, for each department. So the records department, marketing, sponsorship, all the contracts that we do, production, everything like that comes up through the organization, the membership. You're saying that you're the custodian of records for all those departments? Correct. So I want to ask you about awards. Wait, hold on. About awards for a couple of moments. What types of records does the Recording Academy keep with respect to awards? You mentioned the Grammys earlier in your testimony. So the awards department manages the history of the organization's awards for nominations and awards that are given out. Also manages the submission process. So there's online entry program that artists submit their recordings for the prior year, and then that process is managed, and then the membership votes on those for that year, and then the decisions are made at the awards show. So I think you just told the jury a little bit about awards history that the Recording Academy might keep year to year. Is that fair? Correct, yeah. Does the Recording Academy keep records with respect to a specific artist? Yes, every single artist. When you say every single artist, would that mean that if someone's nominated or has been nominated for a Grammy Award or won a Grammy Award, the Recording Academy would keep records for that artist, tracking those things? Correct, yeah. Do you know if the Recording Academy keeps records with respect to an artist known as R. Kelly? Yes, we do. Have you received records relating to and awards for an artist named R. Kelly? Yes, I have. Okay, Your Honor, I want to publish for the witness, not for the jury, an exhibit. And this is just for the witness, not for the jury yet. This is on the computer. There's a brief pause. Your Honor, can we have one moment? And then Lionel would finally wake up and say, have you got a hard copy you can show her while you're trying to get this to work? Then Julian, well, she can see it. It's just, I'm going to clear out this stuff. Then there's another pause. And then Julian, Ms. Mecklenburg, I think we got this fixed. Do you see an exhibit in front of you that's marked as a government's exhibit 329? I do. Have you seen this document before? I have. Can you tell the jury what it is? It's the detailed history report for Grammy wins for R. Kelly. And this appears, and nominations, and this appears, that was Julian. And then she replied, and wins and nominations. Does this appear to be a multi-page document? Yes. So that's 1 page, 2 page, 3 pages, correct? Is that right? Correct. And earlier you told the jury that you're the custodian of certain records, and among those records will be an award history for a particular artist. Yes. This document that we're looking for, Government's Exhibit 329, is this a record for which you are the custodian? Yes. And you reviewed this record prior to coming here to testify today? Yes. Your Honor, at this time, I move for the admission of Government's Exhibit. Any objection? Bonjean, no objection. Okay, it's admitted. You may publish it. Okay, so Julian. Okay. So, Ms. Mecklenburg, I'm showing the jury what's been admitted now into evidence as Government Exhibit 329, and I want to direct you to the top left where I'm hovering a mouse. You should see something that says nominations and wins. Do you see that? I do. And there also is an artist name listed here. Do you see that? I do. Can you tell the jury the artist name that's listed there? It's R. Kelly. Can you tell the jury, based on what you're looking at in Government's Exhibit 329, how many nominations, and we're talking about Grammy Awards, how many nominations Mr. Kelly has received? 26. And would this be lifetime? So from the first time he was nominated for an award to the present day? This is what we have on record. And there's a column or tabulation for wins. Do you see that? I do. Can you tell the jury what that number is? 3. I'm going to scroll down to, I'm going to leave it on the first page, but direct your attention 2 columns or rows in the bottom half of Government's Exhibit 329. So there's a column that says Best Male R&B Performance. Do you see that? I do. Can you tell the jury Can you tell the jury what this column, what this row is, rather, that we're looking at here? Bonjean, counsel, I'm sorry. I didn't hear you because you were leaning down. Can you tell me where you're directing us at? Mr. Julian. So I'm hovering a mouse in the middle of the government's exhibit 329 in about the middle of the page, and I'm asking Miss Meckelborg to tell the jury what is detailed in this row. So, by the witness. And then she jumps back in and says, so that's the win for the best R&B. I think it's vocal performance for I Believe I Can Fly by R. Kelly. It was from 1997. Okay, how about in the row right below that one? Also, the same song. It's a win for Best Rhythm and Blues Song, I Believe I Can Fly, 1997. And how about the row right beneath that one? And then finally, same song, 1997, Best Song Written Specifically for a Motion Picture or Television. And the rest of this record that we're looking at in Government's Exhibit 329, could you tell the jury what we would be looking at? For example, if there is a row of information about a win listed next to it, what that means? That means it was a nominated song. So if I were to scroll through Government's Exhibit 329, I would see 26 entries in total for nominations with those 3 wins that you just told the jury about for I Believe I Can Fly in 1997. Correct, yes. Ms. Meckelborg, do you know whether Mr. Kelly, the artist, R. Kelly, in fact, performed at the Grammy Awards at one point? Yes, he did. So in 1998, the 40th Grammy Awards, he performed the song, I Believe I Can Fly. Can we go into unpublished mode for a moment? Okay, Ms. Meckelborg, I'm going to play a couple seconds of the video for you just to, you tell me if you recognize it, okay? Then the video was played in court. Okay, so I played about 20 seconds of what I've shown to you as Government's Exhibit 4. Ms. Meckelberg, did you recognize the video that I just played? Yes, I did. What was the video that I just played for you? That's a snippet from the 40th Grammy Awards. Government Exhibit 4, you say, is a snippet from the Grammy Awards. How are you familiar with that record? That's part of our records, the custodian records. We maintain all of our copyrighted footage from our television shows. And Government Exhibit 4 specifically, is this something, or 104 rather, is this a record that you actually put in the request to go out and get? I did, yes. Okay, Your Honor, at this time, I move for the admission of Government Exhibit 104 into evidence. Any objections? Brindley, no objection. It's admitted. Bonjean, no objection. Admitted. You may publish. So Government Exhibit number 104, received in evidence. Okay, so Julian, could you make sure our sound is on? I've got it turned all the way up. I didn't hear anything. There's a brief pause. It's working now. Okay, so Ms. Meckelborg, I'm going to play about a minute and a half of Government Exhibit 4 that was just admitted into evidence, and I'll ask you some questions about it, okay? Okay. Said video was played in open court. Okay, Ms. Meckelberg, there appeared to be on Government's Exhibit 4 that I was just playing for you a yellow timestamp across the bottom of the screen. Did you see that when I was playing? Yes, I did. I'm showing you. Can we go into unpublished mode, actually? Okay, I'm showing you what's now marked as Government Exhibit 104. Government Exhibit 104 that I'm showing you, does this appear to be a screenshot of Government Exhibit 4 that you were just reviewing? It does. And does that appear to be a yellow timestamp on Government Exhibit 104? Yes, there does. Is that timestamp 09093711? Yes. Wait. Oh, 9311. Okay. Think about the Prince song. Okay. Mr. Julian, Your Honor, at this time, I move for the admission of Government Exhibit 104 into evidence. Any objection? No objection. The court is admitted. You may publish it. Government Exhibit number 104 received in evidence. Okay, Mr. Julian. Ms. Mecklenburg, the government's looking at Government Exhibit 104 with respect to Government's Exhibit 4 that I just played for you and Government Exhibit 104 that we're looking at right now. Does this appear to be a performance given by the artist known as R. Kelly at the Grammy Awards? Yes, it does. And does this appear to be a performance of the song I Believe I Can Fly? Yes, it does. Government Exhibit 104, does that appear to just be a screenshot of the performance that we were reviewing? Yes, it does. Okay, give me a moment, Your Honor. No further questions. Okay, cross-examine Bonjean. You may cross. Oh, no, he says cross-examine. Miss Bonjean, you may cross. And then Bonjean says, I'm coming. That judge getting on her nerves. But she probably familiar with his old cranky behind. So cross-examination on behalf of defendant Kelly by Miss Bonjean. Good afternoon, Miss Mecklenburg. Hi. You are the custodian of records for the Recording Academy. Is that right? Correct, yeah. And do you actually maintain a copy of the actual album that wins when someone wins a Grammy? Yes, we do it in most cases, but we no longer receive submissions by album. Now it's digital, so right. It depends on what we're talking about. But yes, we would probably have the R. Kelly. I didn't pull that form that from our archives, but we do keep an archive of everything that's won. Okay, right. So going back to the 90s, I guess you maintain an archive, and it would be your understanding that the album, I Believe I Can Fly, there would be some type of copy of it there. I believe so, yes. And with all of the paperwork or like the inserts and any of the performers who were in the album, hold on a second. Performers who were on the album also be included? Yes. And you didn't have a chance to look at those albums in any detail, is that right? I didn't pull any physical copies. Okay, were you aware that the complaining victim's father, in this case, was on the album Love Letter, which was nominated for a Grammy in 2011? I was not aware of that, no. All right. Were you aware that the complaining witness father was on an album called The Chocolate Factory in 2003? I was not aware of that. And he did get a nomination for both of those albums for Grammys, right? I can't speak to that directly. Well, can you I'd have to look it up. Well, do you have the record in front of you? We just admitted it into evidence. Do you need a copy of it? Oh, yes. If it's on the history, I'd have to look up the name again and sure, confirm that. I'm sorry. So, Mr. Julian, Your Honor, can we have a sidebar briefly? So they have a sidebar. And then, of course, it's redacted. So there we go back to Miss Bonjean. I'm going to give you a paper copy if you don't mind. That's great, thanks. A little easier. Okay, Miss Bonjean, may I approach the judge? You don't need to ask permission to approach. None of the lawyers, if they approach the witness, was to ask permission. Just do it. Okay, sorry about that. My daughter walked in. Okay, so the judge says you don't need to ask permission to approach. None of the lawyers, if they approach the witness, has to ask permission. Just do it. Bonjean, got it. So then Bonjean goes on and says, okay, quickly, Ms. Mecklenburg, are you able to confirm that Mr. Kelly was nominated in 1999 for a track known as When a Woman Sped Up? Do you see that at the top of page 2 of this document? And let me stick a pin here because y'all know Country Wayne. Love him some R. Kelly, okay? And so, he's basically, I think he did like a skit that blew up, where he was pretending to be one of those people that say that they're not listening to him anymore, and then they're sneak listening and his friends call him out. And then at his concerts, he plays R. Kelly's music and, have the crowd singing along. And so I think it was yesterday or the day before yesterday, whatever day this testimony was, so that was the day before yesterday, he had done a skit, and he doesn't do his skits on Instagram anymore. He posts them on YouTube. So he takes the video from the YouTube skit for Thursday and then puts "When a Woman's Fed Up" over over the video. And I'm just like, he is so messy. Okay, so I guess with Rashona, no, it wasn't. When did Rashona testify? Rashona testified yesterday, so it was yesterday when he did it. So it was while Rashona was testifying, he put this video up with "When a Woman's Fed Up" over the video. So I thought that was funny. He is so silly. But anyway, let's continue on. So are you able to tell us whether or not the complaining victim's father was the guitarist on that track? No, because it's just an artist nomination. So what we have, if the artist is nominated, does that mean that that his support ensemble also gets nominated? No, it's specifically an artist category, and the rest would receive participant acknowledgement. I see. And then in 1999, he was also nominated for an R&B album, and he being Mr. Kelly, called The R. Do you see that? I do. And are you able to tell us whether the complaining witness father was a guitarist on the particular album? What was the name? And then Mr. Julian, Your Honor, Bonjean, I'm not. Mr. Julian, can we have a sidebar? Bonjean, relax. I'm not going to be announcing names. Julian, well, I'm going to sidebar about something different. Judge, no. Julian, can we have a sidebar? The court, she says, well, let's move on. Ask another question. Bonjean, okay. I think the name we're using is Brandon, but that doesn't mean anything to you, does it? No, it does not. Okay. Would your answer be the same for the album that was nominated, he being R. Kelly, was nominated for in 2003 called The Chocolate Factory? Yes. Okay, hold on a second. Yes, my answer would be the same. And that was nominated for the Best Contemporary R&B Album, right? Yes. Okay. And you can't tell us whether the complaining victim's father was nominated or was a guitarist on that particular album, right? That's correct. And then finally, in 2011, Mr. Kelly was nominated for an album called Love Letter, right? Do you see that? I do. Okay. And my question is the same. Are you able to tell us whether or not the complaining victim's father was on that album as a guitarist? No, correct. I cannot tell you that. Is that something you could get if you wanted to look? If you went back to your archives, is that information you could obtain if you were asked to obtain it? If that information was contained in the jacket of the album and we had the album, right? Okay, the government didn't ask you to bring that information, right? No, I didn't. No, they didn't. No, I didn't. No, they didn't. Bonjean, thank you. Judge, any questions? Mr. Brindley, no. Nothing on behalf of Mr. Brown. Hang on one second. This is Julian. Then the judge, all right, you can step down. Call your next witness, Mr. Julian. Judge, can you give us 1 second? Brief pause. Julian again, nothing further, Your Honor. Judge, you can step down. This judge is out of control with his 85-year-old self. Call your next witness. So then Mr. Julian, the government calls Detective Dan Everett. Dan Everett, plaintiff's witness, sworn the court. You may remove your mask when you testify, sir. You may question the witness. Direct examination by Mr. Julian. Good afternoon, sir. Good afternoon. Would you please tell us your name and spell your name? My name is Daniel Everett. Everett, Everett. Sir, are you retired? I am. What was your most recent employer before you retired? Chicago Police Department. How long did you work for the Chicago Police Department? I worked for the Chicago Police Department 29 years and 6 months. When did you start working for the Chicago Police Department? I began on January 3rd of 1977. What was your title when you began working for the Chicago Police Department? Patrol officer. What was your title when you retired? Police detective. At some point in your career with Chicago Police Department, did you begin to investigate child abuse matters? I did. And approximately when was that? 1983. I was promoted to youth officer. Did you ever work in what's referred to as the Special Victims Unit? I did. What's the Special Victims Unit? Special Investigation Unit is a specialized unit within the Chicago Police Department that investigates. They're focused on child abuse victims under the age of 13, along with other minors that may have been abused by family members or by anybody with a position of authority. Special Investigations Unit also conducted internet crimes against children, which included child exploitation and child porn. When you start working on the Special Victims Unit, it was January. When did you start working on the Special Victims Unit? It was January 1999. How long did you work in that Special Investigations Unit? For approximately 7 years, until I retired in 2006. What was your job title when you were working in the Special Investigations Unit? It was youth investigator. And at one point, we were transitioned and our title was changed to detectives. Did the duties change from when you were an investigator to being a detective? Let me see. No, not at all. So, as either an investigator or a detective in the Special Investigation Unit, what was your duties? Our duties were to investigate, again, child abuse. Mainly, Special Investigations Unit was internet crimes against children and CP. Okay, so right now I want to ask you about the time period of October 2000. Based on what you told us already, were you working as either an investigator or detective in the Special Investigations Unit in October of 2000? Yes, I was. In October of 2000, did you receive an investigative assignment relating to a minor we're referring to in this case as Rishona? Well, they're referring to her as Jane, but we know who she is. So, yes, I did. How did you receive that information? I was assigned the investigation from my sergeant, Sergeant Chesinski. Interesting last name. Now, did you take any investigative steps based on receiving the information that you received from your sergeant? Yes, we did. What was the nature of the information that you received? The nature of the information, first of all, it was from an anonymous complaint. Bonjean, I'm going to object to any eliciting of hearsay. Julian, I'll rephrase the question, Judge. All right, Julian. Without being specific, can you just at a high level tell the jury what was the nature of the information that you received from your sergeant? We received information of allegations of child abuse regarding a known celebrity with a minor child. Now, y'all, you guys remember I did a video a while back, and it was about Drea, Kelly's ex-wife Drea, who refuses to stop using his last name. But the video was about Drea filing a police report about abuse of a minor, and people were saying that the document that she filed, or the abuse thing that she filed, was about one of her kids. And I was just like so confused, because I was like, dang, if that, if she had done that, it seemed like that would have been all over the news, or maybe it was just a Chicago thing. So now I'm wondering, so is this report, was this from Drea? Is this that same report? Because I can't remember what year it was from that, the video that I did of what year it was that she filed that report. But I just thought this was, interesting, maybe just a coincidence. And so it says, we received information of allegations regarding a known celebrity with a minor. Was the minor who was the subject of the information that you received, was that Rishona? Yes. Did you take some investigative steps based on receiving that information with respect to Rishona? We did. Did you go out and interview Rishona and Rishona's family after receiving that information? Banjin, object to the leading. Julian, Just Foundation judge, overruled. Julian, did you go out and interview Rishona and her family after receiving that information? I did. And approximately what month and year was it when you went to interview Rishona's family? It was December of 2000. Okay, where did that interview take place? At a small shoe store in Oak Park, Illinois. Who was present with you when you went to do that interview? It was myself and my partner, Joe Rees. And Joe Rees also either an investigator or a detective? Yes, he was. Who was present besides you and Detective Rees? Who was present at the shoe store when you conducted the interview? Well, Rishona was present at the store along with her mother and her father. Okay, why did they pick a shoe store to go and investigate? Did somebody work in the shoe store? That's interesting. So now, who did you interview, if anybody, that day? We interviewed the mother and the father, and then interviewed Rishona. I want to focus on your interview of Rishona right now. Did you ask specifically Rishona whether there was a relationship between Rishona and Robert Kelly? I did. What did Rishona say in response to that question? Rishona informed me that Robert Kelly was her godfather, and he never abused her and would never do anything like that to her. You mentioned that you also interviewed Rishona's parents that day. I did. Did the account of Rishona's parents contradict the account from Rishona in any way? No, it was very similar. Based on those 3 interviews, what you just told the jury about, did you take any further investigative action? Can you repeat that? Yeah. Based on those 3 interviews you just told us about, did you take any further action? Well, we made out our police reports and basically unfounded the investigation at that point. And what was the basis for your recommending that the investigation be unfounded at that point? Well, we had an alleged victim telling us that no crime was committed with her, and along with what her parents' statements were. Can I publish something to him? This is Julian asking the judge. And then he says, Detective, I want to show you what's marked as Government's Exhibit 315. It should be on the screen in front of you. Do you see what's marked as Government Exhibit 315? It's being published to the jury right now. If we could just... Okay, do you see that, Detective? I do. Have you seen Government Exhibit 315 before? Yes, I have. And can you tell what is this? It's a report that we submitted after we were informed in October of 2000 of the allegations of Robert Kelly with a minor. Okay, how do you recognize this report? Well, my name and star number are on it. along with my partner's name and star number and our commanding officer. I'm going to scroll down to the bottom of this. So this appears to be a 2-page document. Yes, and I'm showing you the second page of Government Exhibit 315. Yes. Do you see that? Yes. Do you see your name on the second page of Government Exhibit 315? I do. Is there a signature? Is there a signature? Yes, that is my signature, sir. Is Government Exhibit 315, with the exception of being heavily redacted, is this a fair and accurate copy of Government Exhibit 315 from the last time? Okay. From the last time that you saw it? It does. Okay. Your Honor, at this time, I move for Government Exhibit 315 into evidence. Any objection? Bonjean. Yes, Judge. Let me look at the redacted version real quick. Brindley. We object to hearsay, Judge. The judge. Pardon? Then Julian. He had a hearsay objection, and I can respond to that, Your Honor. The judge. Well, I don't think. Well, it's the Bonjean. I mean, it's a police report, that is. And then the judge. I don't think it's being offered as for the truth, so it wouldn't be hearsay. Julian, that's exactly what it is, Your Honor. And then Brindley, Judge, I withdraw the objection, in fact. All right. Okay, hold on one second, Judge. Brindley. Mr. Thompson's made me think better of it, Judge. All right, what about Miss Bonjean? Are you still, give me a minute. I'm coming, Judge. All right. Then there was a brief pause. And then Bonjean, not offered for the truth. No objection. Judge, all right. It's entered into evidence and you may publish it. So they publish the exhibit. So then Julian continues. So Detective Everett. Now, we're showing the jury what's been admitted into evidence as Government Exhibit 315. You just told me a little bit about this. Can you tell the jury what we're looking at here in Government Exhibit 315? Yes, basically, it's a summarization of the allegations that we received in October, along with the December 2000 when we went to the shoe store and interviewed Rishona and her parents. Now, Detective Everett, I'm scrolling to the second page of Government Exhibit 315. Do you see some entries on the second page of Government Exhibit 315? Yes. The interview you just told me and the jury about with Rishona is that an interview documented in summary form on the second page of Government Exhibit 315. And there's a R/I. Can you tell the jury what R/I stands for? It's reporting investigators. Would you mind reading this sentence for the jury? Reporting investigators then interviewed and redacted and was informed by her that she had never been sexually abused in any manner by her godfather, Robert Kelly. She indicated that these indications are completely untrue and is treated very well by Robert Kelly. At the very bottom of this report, this second page of Government Exhibit 315, there are the words unfounded in all caps. Can you tell the jury what that's about? Again, after interviewing the parties, we unfounded it basically because we did not have any statements from Rishona or her parents substantiating what the charges were or the allegations were. And that sentence you just read to the jury, would that have been a part of your basis for recommending that this investigation be closed as unfounded? Yes. Have you seen an unredacted version of this report, Detective? I have. Is Rishona's age documented somewhere on this report? The unredacted version. Yes. Okay, so we're clear. Were we Okay, this investigation that you were telling the jury about in December of 2000, did this investigation involve a minor? Yes, it did. Thank you. So, detective, now I want to ask you about approximately December of 2001. So, about a year later, do you know if a new investigation was opened in about December of 2001 concerning Rashona and Robert Kelly? Yes. I'm going to fast forward to the following year, February 1st of 2002. Without getting into the specifics, did you receive a copy of a videotape? Yes, I did. Who did you receive that videotape from? From Jim Derogatis of the Chicago Sun-Times. And who is Jim Derogatis? Jim Derogatis at the time was a music critic for the Chicago Sun-Times. Fair to say that he's a reporter, a news person? Yes. After receiving that videotape from Mr. Derogatis, did you watch the videotape? Yes, I did. The same day? Yes. Generally speaking, what was depicted on that videotape? It was a male adult performing various acts with a young-looking female. At the time that you watched that video, so February 1st, 2002, did you recognize the young-looking female on that tape? I did. And who did you recognize that young-looking female to be? I recognized her as Rashona, that we interviewed back in December of 2000. And how did you recognize her as being Rashona? From the facial features. Is it because you met Rashona in person? Exactly, yes. Do you, as you sit here now, do you know when that video was recorded? The video you got in February of 2002. No, I do not know. At the time you were viewing it, so on February 1st, 2002, based on what you know about the investigation, would Rashona have been under the age of 18 on that date and time? Bonjean, I'm sorry, objection on what date? Julian, February 1st, 2002. Bonjean, thank you. So back to the witness. Yes. So, Mr. Julian, on August 15th, so now I'm coming to the present time this year. Monday, August 15th this year, did you review a copy of a video? Yes, I did. Okay, wait a minute. Let's put a pin here. Okay, so he interviewed Rashona in 2000, right? December of 2000, I think he said. And they said, she wasn't in a relationship. So they had this police report that was filed in October. Wait, let me go back up here because I want to make sure I'm saying the right thing. So December of 2000, they interviewed Rashona and her parents at this shoe store. No, not sure the significance about the doggone shoe store. So they had gotten a report in October of 2000, is that right? About abuse. So somebody filed the report, and if it's the same report that I did that video on. Okay, so it says, did you know if a new investigation was opened in about December? Okay, so the new investigation, so they got a report in October. They went and interviewed the family in December of 2000. So at that time, Rashona would have been 16, because I think her birthday is September 1984. So December 2000, she would have been 16, right? She would have just turned 16 in 2000. Okay, so then in 2001, the case was reopened. Okay, and then without getting into the specifics, did you receive a copy of the videotape? So detective, now I want to ask you about approximately December of 2001. So about a year later, do you know if a new investigation was open? He said yes. I'm going to fast forward to the following year, February 1st, 2002. Without getting into the specifics, did you receive a copy of a videotape? Yes, I did. Who did you receive it from? Jim Derogatis. Okay, so back to December 2001 when they reopened the case. Then Rishona would have been 17, right? She would have been 17 in 2001, December. Okay. I just want to keep this clear in my head. She still would have been 17 in February 1st of 2002. And this is why I am confused. So she would have been 17 December 2002 because her birthday is in September. So she wouldn't have turned 18 until September of 2002. Okay, so then they talk about receiving the video. And then, did he watch it? He said yes, the same day, yes. Generally speaking, what was depicted? He tell him what was depicted. He says, at the time that you watched that videotape, so February 1st, 2002, did you recognize the young-looking female? I did. And who did you recognize that young lady? He recognized her to be Rishona, that he interviewed back in December of 2000. And how did you recognize her? And he said the facial features. And it was because you met Rishona, correct. Okay, he says, do you, as you sit here now, do you know when that video was recorded? The video you got in February of 2002. No, I do not know. At the time you were viewing it, so on February 1st, 2002, based on what you know about the investigation, would Rishona have been under the age of 18? So I missed that under part because I was so confused right there. So under the age of 18 on that date, and then he said, then Banjine objects. And then he says, February 1st, 2000, she says, thank you. And then the witness says, yes, she would have been under 18. So she would have been 17. Okay. So Julian, on August 15th. So now I'm coming to the present time. Okay, then did you review the video? He says, yes, I did. Give me 1 second, brief pause. Julian, detective, I just handed you was marked as Government Exhibit 1. Have you seen that disc before? I have. When did you last see that disc? This morning. How do you know what you saw? How do you know that you saw that disc this morning? Oh my God. He said, I initialed it and I dated it. Did you review the contents of that disc? I did. Is there a video on that disc? Yes. The video that you saw on that disc that you have in your hand, Government Exhibit 1, did it appear to be consistent with the video that you received back in February of 2002 from Jim Derogatis? Yes, it was. I'll take that back from you. Document tendered. So now, detective, I want to come back to 2002, February, after you got the tape from Mr. Derogatis. At any point in the month of February 2002, did members of law enforcement go out to an address at 1010 West George Street in Chicago? Yes. Did law enforcement, well, you tell me, when did law enforcement approximately go to that residence at 1010 West George Street? I don't recall the exact date. Could it have been about February 11th of 2002? Yes. Yes, could have been, yeah. Okay, did law enforcement have contact with the contractor at that home? Yes. And ultimately, did law enforcement receive consent to enter into that home? Yes. After law enforcement received consent to enter into 1010 West George Street, were you called out to the property? I was. Did you go? I did. And what, if anything, did you observe relevant to your investigation when you arrived at 1010 West George Street? I observed several similarities that I viewed in the videotape back in February that matched, different parts of the settings in the residence at 1010 George. And what, if anything, did you do after you observed those similarities? We requested an evidence technician. Do you know if that evidence technician came out and took some photographs? We did, or he did. So, Detective, I'm going to show you what's marked as Government Exhibit 112. And some of these have a number 112 followed by a letter. I'm showing you right now what's marked as Government Exhibit 112U. Okay, we're going to do this as a group. So, have you seen Government Exhibit 112U before? I did. I have. What does Government Exhibit 112U appear to depict? It's a cover sheet that the crime lab or evidence technicians would use upon being assigned an assignment. In this case, they would put on the upper line, put the police report number, the type of incident, the type and the date and time, and then the evidence technician's name, star number, and unit of assignment. Do you see a date in Government Exhibit 112U? Yes, I do. And what's that date? 11 February 2002. Do you see an offense incident in Government Exhibit 112U? Yes, I do. Can you tell me what that offense incident is? CP. There is a photographer's name. Do you see that? Yes. Do you know who that person is? Yes. Who is that? That was the evidence technician. So now I'm going to go to Government Exhibit 112A. You've seen Government Exhibit 112A before? Yes. What's Government Exhibit 112A depict? That's the building at 1010 West George Street that we entered, and that appears the front entrance. Did you go into this building? Yes, we did. Do you see a date in the bottom right corner of Government Exhibit 112A? Yes. Can you tell what does that date appear to be? February 11, 2002. Does Government Exhibit 112A fairly and accurately depict the outside of 1010 West George Street on February 11, 2002? Yes, it does. I'm going to show you what's marked as Government Exhibit 112B. Have you seen Government Exhibit 112B before? I have. What is it? That is the rear entrance of the same building. Does Government Exhibit 112B fairly and accurately depict the rear entrance of 1010 West George Street on February 11, 2002? It does. How about Government Exhibit 112F? Have you seen that before? Yes, I have. What is it? That's the inside of the building that we were at, and it's again the same setting that I saw in the video. Do you see a date in the bottom right corner of Government Exhibit 112F? I do. And what's that date? February 11, 2002. Does Government Exhibit 112F fairly and accurately depict a room in 1010 West George Street as you observed it on February 11, 2002? It does. Now, I'm showing you Government Exhibit 112D. What is this? Basically, a different angle of the same room that from the last exhibit. And does this photograph, Government Exhibit 112D, fairly and accurately depict that room in 1010 West George Street as it appears on February 11, 2002? It does. I'm showing you what's marked as Government Exhibit 112Q. Have you seen Government Exhibit 112Q before? Yes. What is it? Bedroom in the same building. You went into this room? I did, I believe. Does Government Exhibit 112Q fairly and accurately depict, they give the address on February 11th. It does. So, Julian, Your Honor, at this time, I move for the admission of Government Exhibits 112U, A, B, F, D, and Q into evidence. Excuse me. Any objection? No response. Okay, hearing none, they're admitted. You may publish. Aforementioned government exhibits received in evidence. Then Mr. Julian asked the question. So Detective Everett, now we're showing the jury what's been admitted into evidence as Government Exhibit 112U. And you told me a little bit about this a moment ago. There's a photographer's name there. Do you see that? I do. Was that the evidence technician you called out that day? Yes. Is it fair to say, based on what the jury's looking at, Government Exhibit 112U, and based on the answers you gave me when I was asking you about this, that there's some sort of CP investigation that's ongoing? Yes. What CP investigation was ongoing when these pictures were taken? The investigation regarding the videotape that we had received. So now I'm showing you and the jury what's admitted into evidence. Okay, so they basically just go over what they have just stated and asking him what's depicted. He's already stated what's in there. So we're going to skip through this. Excuse me, we're almost done. 2 more pages. Same building. Again, this is inside the same building. Yes, I'm going to show you Government Exhibit D. So he goes through all of that again. And then he says, after viewing the video, it was very obvious, and this is the detective talking. After reviewing the video, it was very obvious that this was the setting where it took place. Is that why you called out the evidence tech? Yes. So earlier during your direct examination, you say that you saw some things that were consistent with the videotape. Is that correct? Yes. Was this the room that you were talking about? Yes, it is. Thank you, detective. The following day, after going out to 1010 West George Street and having an evidence technician take these photographs, did you attempt to interview Rashona's family again? I'm sorry, can you repeat that? I said the following day, so still in February of 2002, February 12th, right? Did you attempt to interview Rashona's family again? We did. We attempted, yes. You said you attempted. What do you mean by that? Well, we were unsuccessful in contacting them, making contact with them. We were unsuccessful. Bunging, objection, speculation. Judge, objection sustained unless he, and then they cut him off. And then Julian says, detective, did you report to what you knew to be Rashona and Rashona's family's residence? I did. Were you able to make contact with them in the residence? No, I was not. Julian, give me one moment, Your Honor. Then Julian comes back after a brief pause. Detective, I want to ask you a couple more questions about Government Exhibit 1. You said you reviewed the contents of that disc. Did you watch the video in its entirety? I did. Bunging, objection, foundation of when? Julian, I'll rephrase the question, Your Honor. Judge, okay, when? Go ahead, ask him when and then. Then Julian cuts him off and says, so let's break this down into a couple of questions. Detective, in February of 2002, did you watch the video that you received from reporter Jim Derogatis in its entirety? Yes, I did. On Monday of this week, did you watch what's marked as Government Exhibit 1, that video in its entirety? Yes, I did. This morning, did you watch what's marked as Government Exhibit 1 in its entirety? Yes, I did. Did you initial the disc after watching it in its entirety? Yes, I did. Okay, nothing further, Your Honor. Then the judge, okay, we'll suspend until 10 o'clock tomorrow morning. We'll have the cross-examination then. We certify that the foregoing is a correct transcript from the record of proceedings in the above titled manner. And then the court reporters sign off on it. And I noticed that they do their transcripts a little different than the Eastern District of New York, because in the Eastern District of New York, they are kind enough to put a list of who all interview people or question people. So, for example, it will tell you that the Julian guy interviewed, like who the witnesses were, what page number. You could find all that information on what exhibits were admitted into the case. So if you needed to find anything within the transcript, you just went to the final pages and it would tell you the page number and the line number where you could find that information. But in Chicago, they don't do that. So anyway, guys, that's it. This was the conclusion of court on August 17th, 22. So go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.